Don't use this computer. Yes, Sister Anne.
Good afternoon. My lady, I'm going to do a little bit of a continuation of my submission from yesterday, as I've forewarned.
You did?
But also, I'm going to start by dealing with a short point of my Lord Kerr's about appeals, which he raised with me yesterday, which is just a little bit of new law to put into context how these appeals can get into the Court of Appeal. I shall deal with that shortly. I propose thereafter to deal with the clause 33 point, the paragraph 33 point, then go into the attorney's arguments on section 17 and paragraph 24, and that will neatly, I hope, segue into dealing with the Article 9, 10.2 and the 10.2 points that were raised by my friend Mr. Schofield, and making some reply submissions in relation to those, insofar as I've not been able to do so already. That's my plan. Dealing first of all, there should be some more law on the bench in a very small package of about 3 pieces of paper. And this addresses a point that my Lord Kerr raised with me. Can I just say, first of all, Lord Kerr, that as I understand it, most of the cases in discrimination that will have gone to the Court of Appeal will ordinarily have been employment cases to which these limitations on appeal routes will not have applied. But we are dealing with, and I'll come back to this point later on in my submissions, with a goods, facilities and services class of case, started by a civil bill in the county court. And the appeal provisions that deal with the civil bill are set out in the County Court's Northern Ireland Order 1980. We've already got in the bundle Article 61, which is the one that you will have seen yesterday. But I thought it would be helpful just to flesh out the other parts of that order, because it provides in Article 60 where there has been a decree of a county court made in the exercise of its jurisdiction conferred by Part 3, and Part 3 is the civil appeals, the original civil jurisdiction part. You'll see that from paragraph 1. There's the right of rehearing in the High Court, and then by Article 62, which is in the box, there is a right to apply for a case stated from the High Court, which goes to the Court of Appeal. And Article 62, as for Article 61, which we saw, has the same prohibition on further appeals. So there was an opportunity in theory. I know Mr. Schofield argues that that opportunity didn't arise because of some technical point on the process, but we had understood that there was the potential for a rehearing. Whether or not that is the case, in ordinary civil litigation in the county court, you have a case-stated appeal, which is then final in the Court of Appeal, or you go to the High Court and then a case-stated appeal, and you'll see exactly the same text. It'll be final. So that's just to make good the submission that I made to you yesterday. I shall take no more time on that, but I felt duty-bound to flesh out what I'd said. And that brings me next to my next point, which is paragraph 33. Now, I want to start by saying we've already made submissions on paragraph 33 in our case, and I don't propose to go through them again. I haven't got time to deal with them in that way. But I want to just respond to the way the attorney has dealt with this. 1998 was a critical year for the United Kingdom because there was constitutional legislation for England and Scotland, I beg your pardon, Northern Ireland and Scotland. And in the consequence of that, it was recognised that devolution issues could arise in all the different parts of the United Kingdom outside England and Wales. And I believe there's a similar provision in the Government of Wales Act at some point. I haven't got time to look that up. What paragraph 33 seeks to do is two things. First of all, to deal with what I'll call a comity point. It allows representatives of the country at large, that is, the Attorney General, the Advocate General for Northern Ireland, who ordinarily holds the post of the attorney holds that post, the Advocate General for Scotland, to refer cases to the Supreme Court. So it enables somebody in Scotland, for instance, to say something's happening in Northern Ireland which may affect the government of England in some way or another. And they can become parties to the legislation if they wish to. The rules of the court that apply and sit behind that required, prior to the Court of Appeal hearing, although the substantive hearing, that the Attorney General in London was served with process and asked if he wanted to become a party, and the Advocate General for Scotland ditto. They declined, and they did not become parties. So what we get out of that is this, that there is an intention in the phrase to which he is or they are a party, that there is an election process. The law officers, if I can call them collectively that, of the different parts of the state, choose whether or not to engage in a piece of litigation which raises devolution issues. There is a cognate provision to this in relation to Scotland, which I suspect Lord Hodge knows about, and I think may well have been debated in front of you in the past. But they make a choice. Now that's an important point, because it's obvious that in making that choice, there's an election to engage in civil litigation. And we take out of that this proposition. It's obvious that this provision is designed to advance due process and not to retard it. And any construction of it must involve considering it from the point of view of due process. Now, there is nothing within the text of paragraph 33 itself which says exactly at what time the application has to be made. If there were, we wouldn't be having the debate that we are. But we say it is implicit, but very clearly implicit, that it is part of due process, that it is to be interpreted in that way. I'm about to make that submission good to you, because this court knows all about due process in all sorts of ways. The obvious comparator situation would be a reference to the Court of Justice, as Lord Mance put forward. Now, the question that comes in such a case like that is asked, it's in fact, I think, on the appeal form, that you have to say whether you're going to ask for a reference at some stage or another in the course of the case. Our submission is very straightforward. This is the point that I wanted to make, in addition to what's written in the argument, is that if the attorney thinks that this is a point which is so important that it requires the input of the Supreme Court, he should say so at the point that that arises. But equally, this is not an appeal provision. The attorney does not have a right of appeal after a judgment of the Court of Appeal, or indeed any other court in which he's engaged under paragraph 33. So what he can't do is use 33 as an appeal mechanism. He's not given that right. And that's my point about due process. It is to assist the deciding court to reach judgment. And what happened in this case is the attorney did not ask for a reference before the deciding court made its judgment. In practice, what he sought to do, and he was pretty frank about it, frankly, in the Court of Appeal when the application was made, was to treat it as an appeal process, which he doesn't have
Well, if, as soon as the judgment was delivered, it occurred to the attorney that the Court of Appeal had unexpectedly to him dealt with a devolution issue in a way that he had not anticipated. And if he'd immediately leapt to his feet and said, we'll have a notice under paragraph 33 with you later today, would he be entitled to insist upon the Court of Appeal complying with paragraph 33?
My Lord, on the argument that I've given here, if something has arisen in the course of it, and I mean, it's not unknown for a judge to think of a point and put it in a judgment which has not been anticipated by the parties, due process would allow that point to arise, that argument.
So it's not an absolute cut-off. It depends on due process, does it?
That's the submission that we made. And if I may say so, we said that with some vehemence because the costs involved in dealing with this, there had already been 3 days of argument about the actual wording and discussion about whether a devolution notice should even be issued, which had taken place. So it's not as if the whole thing had come at very short notice. That's why I put this extra point to you in this way. Of course, if something unexpected arises, then due process would not cause one to think that, that the attorney's, as it were, lost his chance. But if all the arguments that the attorney wants to make have been listened to by the court, and the court then decides against him, what he can't do, essentially, is come along and say, hang on, I want to appeal that. I think you've got it all wrong. I want to go to the Supreme Court. And that's all I really want to say about it. I mean, if it were otherwise, this becomes an instrument of oppression in the course of litigation. And I'm going to come back to this point. Litigation about £35.60 worth of cake. Now, we've made the other points. I can tell you that it was actually myself that informed the parties of my latest judgment in Re L, which is the case about the point at which the judgment is completed. We've taken points about that. They're dealt with in the course of the judgment. But I really want to get this point out. This clause cannot be interpreted as an instrument of oppression of the parties. It would be quite wrong to do that. Now that brings me to the...
I assume that Section 33 wouldn't exclude the court's usual power to restrain an abuse, which would cover your case of oppression, wouldn't it?
Absolutely so. And
well, if that's the position, I mean, do you say that the Court of Appeal has treated it as an abuse? The Court of Appeal didn't take this argument. I'm not sure it was put to it.
It was, most certainly was.
It was. Well, the Court of Appeal seems to have taken a slightly different, technical argument, namely there's a backstop consisting of delivery of judgment.
In a way, they march hand in hand, because what the Court of Appeal felt was, we've given our judgment, and what we don't want to have to do is to be reconstituted some years, or a year hence. In this case, their judgment was in 2016, and it would have been some years hence, having been told by the Supreme Court what it thought about Article 9.2 and 10.2. And it considered its voice had spoken. And that was the conclusion that it reached. It may not have articulated it precisely in the terms of abuse, but certainly it was our skeleton to say that it was an abuse. And if you look in my case, you can see how we put it. There was no tender of costs from the attorney. We suddenly thought we'd won the case, and now we were being told, no, there's going to be another 2 years of litigation. It's not a pleasant... it may be justified, it may not, but you can see the approach that we took to it, that the attorney's approach was abusive in the sense that it would delay and prolong this litigation for a considerable period of time, wholly disproportionately to the issue, from our perspective anyway.
From your perspective, it hasn't affected the position, has it? Because you're going to be faced with a section 34, paragraph 34 reference anyway. So
Not
exactly,
at all.
No?
Because paragraph 33, the point that was raised this afternoon with the attorney, paragraph 33 could unpick the judgment.
Yes, certainly.
Paragraph 34 cannot.
I know, but the points of principle, if you're complaining on behalf of the Commission, would arise all the same. On behalf of Mr. Lee, I can see the difference.
My lord has my point.
Yes, yes.
Mr. Lee keeps his £500, but you get the position decided against you.
Well, and this is a point at which the two interests, if not diverge, it's not the right word, but they're separate. The Commission wants to do right by the law. Let us be entirely clear about that, and is happy to discover what the law is. But from Mr. Lee's point of view, this is what was a relatively small incident in his life, but which has become enormously significant and continues to be so. He's the object of press interest, has been now since, whatever it is, 2014, I think, was the original act. And that's a heavy burden to bear for an individual, and which has to be weighed in the scales. Again, I shall come back to that point later, but I want to press on without saying more about this at the moment. So that's paragraph 33, and you've got our more detailed submissions about the abusive effect of it in our case, which I don't repeat to you.
So the 2 points were a comedy point and abuse point.
The point about paragraph 33 is there's a comity point which is behind it, which is to say, engage at the beginning, get the issues straight from a comity point of view, and that, we say, absolutely makes it clear it's about due process. So the two, comity and due process, go together. Now, I want to move on to the Section 17, effect of Section 17 on veto. I was wondering quite how to put this point in a very pithy epithet, whether to say the attorney's argument on Section 17 eats itself, or whether it proves too much. But it's one or the other, and I will demonstrate how in a moment. But before I do that, I want to put his veto argument into its true context. Section 17 is in the 1973 Act. As I've explained in our case, 2 pieces of discrimination legislation were enacted in Northern Ireland by the Parliament in London. The 1976 Fair Employment Act and the 1989 Fair Employment Act. The 1989 Fair Employment Act used a definition of discrimination, of direct discrimination, not indirect, it didn't cover indirect, of exactly standard form, less favourable treatment on grounds of religion and belief and political opinion. I've been looking to find a case in the bundle, but it's section 49 for your notes, and if you need it in black letter text, I can submit it to you after the case is closed. Now, on his argument, that enactment by London is inconsistent with Section 17, because it means that in an employment case, an employer who discriminates against an individual on grounds of their own political opinion or religion and belief is suffering contrary to Section 17. That poses a question for this court. Did Parliament think Section 17 shouldn't apply in the employment sphere, or did it think Section 17 did not apply, as the attorney says? We submit that it's pretty obvious it must be the latter of those, that it didn't apply in the way that he said. It is true he can raise this argument about Section 17 because the 2 fair employment pieces of legislation were repealed by veto and then reenacted within veto. And that enables him to make this argument that veto in this particular point is inconsistent with Section 17. He may be right, but I would suggest to this court it is a conclusion that you would be very reluctant to reach. In short, because the minister, following the Belfast Agreement and the need to make rapid progress, enacted veto which enlarged, at the request of the parties to the Belfast Agreement, itself an agreement designed to promote equality, had somehow or other undermined actually the reach of legislation which was being enlarged because it now made it subject to Section 17. And this really was the point that in the discourse in front of the Court of Appeal that was telling. It means, in effect, his argument, that in any case in which it is the religious belief or political opinion of the proto-discriminator, Section 17 bites and prohibits an outcome in the case in particular. And that begs the question, how on earth can you prohibit discrimination in the field of goods, facilities, services and employment consistently with Section 17 on his argument? Is it actually possible to do it? Because there will be many cases, probably most, in which it's not possible to distinguish between the ground on the basis of whether it's the political opinion of the alleged victim or the political opinion of the alleged discriminator. Part of the argument that I needed to address in relation to veto, but I didn't get to the end of it yesterday, is that there is usually a false dichotomy about saying, is it the political opinion or religious belief of the alleged discriminator or of the alleged victim? Because the point in a direct discrimination case will always be that there is a non-sharing of the political opinion. In any direct case, on grounds of political opinion or religion belief, will be because the alleged discriminator does not share that belief or opinion with the alleged victim. I mean, it's possible to contemplate association cases which will be more complicated, but in any typical case, that is what there will be. So arguments about whether it has to be the belief of one or the belief of the other, which is the ground, is, as we say, ordinarily a false dichotomy. One will have it, the other won't. And political opinion includes, and religion belief, includes the absence of a political opinion and religion and belief. So one's left asking the question, if he's right that Section 17 has the reach that he says, is it actually possible in Northern Ireland, of all places, which needs to protect against this class of discrimination, is it possible to legislate to do it? Now, analysed in that way, one can see immediately Section 17 can't mean what he says. It means, we submit, straightforward ex facie discrimination, in the sense that you can't have legislation which identifies on its face some group, remember it refers to class, some group by reference to political opinion or religion and belief. If it does, it falls void of Section 17. It is in many respects a provision designed to prevent the assembly which may have a majority of Republicans or of Unionists or part of the sectarian community legislating in a way which expressly is to the disadvantage of the other side's community. I may go a little further than ex facie because it may be indissoluble in that sense, but what it doesn't cover is discrimination which is absolutely facially neutral, such as veto, which says that all political opinions, all religion and beliefs are all protected, makes no distinction between any of them, and says there shall be no discrimination on grounds of that. Enough on section 17. That's why we say his submission, as I say, eats itself. It proves too much. It reduces the laudable efforts to try and eliminate discrimination in Northern Ireland to a complete nullity. Now, when we get to the sexual orientation regulations, then his argument is no better and no worse than any argument on Article 9.2 and Article 10.2, because his argument there is based on Section 24 of the Northern Ireland Act, that there can't be legislation that's incompatible with the European Convention on Human Rights. And so, although the argument is posed at the level of the legislation, whereas Mr. Schofield's argument is posed at the level of the outcome for the individual, the same issues are in the frame. Now that brings me to our core point. And our core point in this case, and I make this submission on behalf of the Commission, just as much as Mr. Lee, is that prohibiting discrimination is a difficult task. It's difficult because in many cases the grounds for the discrimination are not overt and have to be discovered. It's difficult because the impact can range from the enormous to the relatively small. And therefore crafting remedies is particularly difficult. And in the context of this case, it is super difficult, because in relation to the provisions of goods, facilities and services, we are talking about a prohibition on discrimination in relation to transactions which may range from a box of matches up to a long-term contract. In many cases, and particularly this will be true in a divided community, prohibiting discrimination in relation to goods, facilities and services is a task which is really difficult to police by a commission or indeed through litigation. Take this case. It could not have been advanced by anybody other than the Commission. The loss on an agreed valuation, calculated by reference to the tariffs that have been sent in the jurisprudence, was at the lowest level of £500. That was the compensation for injury to feelings. The actual amount of the cake, as we know, was £36.50. Nobody could litigate this case as an individual unless they were a multimillionaire. The kind of remedy that is involved in dealing with this is small, and this is the class of case that is frequently engaged with in goods, facilities and services. Not cases where you've got sophisticated contractors, particularly, although those do occur, but cases where you've got small exchanges of value of this kind. Now, the reason I emphasize that is that legal certainty in that context is critical. It cannot be the subject of debate. Dealing with discrimination in this class of case involves people knowing their rights, saying, hey, you can't do that to me. It can't have a resolution. It is not possible to resolve it by saying, well, my rights beat yours in this particular case. No, they don't. Let's litigate it. Parliament understands that. All the discussions that took place in the documents which we have referred to are premised on securing a solution in which legal certainty works. So we say, when you approach the questions of Article 9.2 and 10.2, you have to contextualise what Parliament was trying to achieve. I say Parliament, of course, I should say the administration. It would be more correct to say it. What the administration was trying to achieve. The elimination of discrimination in an area of many small transactions which cumulatively affect the economic wealth of the country and indeed social cohesion. All these points are well made in the documents which I showed you yesterday. They are a mile away from some of the other cases which have been cited to you. They don't, I mean, if you look at the Brocky case, for instance, it's not Brocky, I can't remember what the name of the company was, that Arctric or something of that kind, that went to the Brocky printers, didn't know what service they could get for a year and a half, I think it was, of litigation. It went to a board of inquiry and then came out later. We've not gone down that route. We have said that there should be legal certainty and therefore there should be some bright line rules that cover it. And that's why I open my submissions with animal defenders, because this really is a true animal defenders class of case. It is not like Larimore. The Larimore situation was the case of a man who perfectly legitimately had joined the Bahamian police. He had then changed his religion, which was perfectly legitimate, and found himself in a situation in which his workplace humiliated him because he was penalised for not doffing his cap. He had no choices in that context, and he was personally vilified in that way. That's not this class of case at all. So what we submit is that you should resolve this case with an animal defenders approach, which renders the level of inquiry on the 4 stages under Bank Mellet 2 relatively limited. The proportionality assessment is, of course, important, and it is a part of it, but you should readily accept the way in which the state has engaged with this. What is the counter-argument that is made in relation to that? And the counter-argument is, of course, that this is particularly upsetting to Mr. and Mrs. MacArthur because it's forced speech or compelled speech. Now, this requires quite careful analysis in our submissions. The first point I want to make about it is, whilst I can recognise, and we've said so in our case, and as a commission we say this, that those opinions are clearly held, the value of them is very difficult for one to evaluate. The arguments that somebody can, as it were, have a conscience clause and be relieved from the effect of SOR and FETO by reference, particularly SOR, by reference to their conscience, isn't just going to apply in relation to the MacArthurs, but could apply, if you accept that argument, in many other situations with different religious beliefs. And in some cases, those religious beliefs will be objectively discriminatory. The Commission has had cases referred to it, for instance, in which services have been denied to mixed-race couples because there was a religious belief against miscegenation. on the attorney and Mr. Schofield's argument, that can't be examined further. You can find authority in the Bible against miscegenation. It is possible to do that. It can't be examined further. What one simply says is that there has been no allowance made for it within the regulation. There are other examples that one could go through.
Isn't that directly discriminatory against the individuals on the grounds of ethnicity? And that can't be an analogy with an objection to a message on a cake.
I take your lordship's point about the message part of it. I'm focusing it on the religious belief basis for the objection. But my point is that this legislation is cognate legislation to the prohibition on discrimination, provision of goods, facilities and services in relation to race. Indeed, one of the reasons for enacting it in the way that it did, and your lordship will recall this, is because actually in the 2006 Act it says that it should be done in a way similarly to the prohibitions in relation to race. It's actually in the schedule in the power. So it's a powerful point, twice ways over. But I do accept that there is an aspect of this in the sense that it is involving speech. Now, if you look at it from the point of view of the individual circumstances, what might be thought to be the last stage of the Bank Mellet assessment, is this legislation that in this specific context is a push too far? Then you've got to look at the circumstances in the complete round. And as we've said, and I repeat, it was made absolutely clear by Judge Brownlee in her finding that there was here no promotion or supporting of the gay marriage in the making of the cake. And that is at paragraph 40, repeated at 62, MS 3240 and MS 3250. And the Court of Appeal agreed with that, paragraph 67, MS 3212. So this, if I can start at that part of the proportionality assessment, objectively, whatever Mr. and Mrs. MacArthur felt, objectively, the judges below, as a matter of secondary fact, I accept that, have concluded that there would be no sense of promoting or supporting. And that was contrary to Mr. Schofield's submissions. He repeated them yesterday. It's true that Mr. and Mrs. MacArthur felt that they might be identified with it. It was explored in evidence, and it was rejected by the judges below because of the way that the service was provided and the demand that was made.
Mr. Scrufield's argument goes further. He submits that because Mr. and Mrs. MacArthur would regard it as sinful to put the slogan on the cake, irrespective of whether or not they were perceived as promoting gay marriage, because of their fervently held belief, religious belief, that it would be sinful even to put it on the cake, that compelled speech is impermissible in those circumstances.
My Lord, of course he does, and I understand that. But can we, as it were, analyse that submission? Because it has to be looked at both objectively and subjectively.
Stage one, everything's objectively first.
My Lord, yes.
Yes.
And the court, in doing the assessment on the fourth stage of the Bank Mellet approach, must, we submit, look at it both ways round. Forceful and compelling and well-made submissions of the kind that Lord Kerr has referred to are made in this case, and we understand why they're made. But objectively, the court has found otherwise. And that
Court find otherwise that they do not have the subjective belief.
My Lord, that was an inelegant submission. What I meant by that was they found otherwise on the objective side, but while not in any sense denying as a matter of fact the belief to which my Lord has just referred, that they would be considered to be sinful. But it's impossible for the court to engage at any analytical level in that. We can't weigh what it means in this kind of process for it to be sinful. It's objected to, that's it.
That's I find difficult. Religious belief is not something which is objectively verifiable or objectively capable of being given weight, but it's nonetheless something which is given a lot of weight by courts and by protection of human rights. And the Larimore case is a classic example where he wasn't to be taken as associating himself, but he certainly felt a strong objection to having to participate in, even neutrally, in religious prayers. And that was given weight by the court. So whilst you are right, I mean, what value does one put objectively on religious belief? The court certainly recognise that individuals subjectively share strong beliefs of one nature or another and give that weight in their judgments.
My Lord, I accept every word that you said in relation to that.
Yes.
But my point about it is that it also has to be weighed in an objective context. In the Larimore context, it's perfectly clear that it was objectively humiliating for him to be required to doff his cap, to be, every time prayers were said, every single day, I think it was, if I remember rightly. Certainly it was when the colours were run up.
No, I don't think it was every day, but anyway, it doesn't matter. Yes.
Frequently.
Yeah.
He is identified as an outsider, if I can put it that way. And what's more, that outsider it goes to the heart of his personal being because it's dividing him by belief from his fellow workmates. Now, objectively, this case is completely different for the reasons which I've said and the reasons that the judges have found. Objectively. And that's why I say that in the proportionality assessment, the court can make and should make those distinctions. This is not...
I do find this difficult because that is suggesting that you do not give, courts should not give real weight to intensely personal beliefs which the court may or may not itself share.
My Lord, that is not the submission I make, and if it's read as such, then it's, if I may say so, it's a failure of my advocacy. It's not that I say that it should be disregarded. This is at the fourth stage of Mellet, where you're looking at proportionality. Then you've got to look at the particular circumstances in which the piece of legislation bites. And that is both the legislation itself, but the context. And in this particular context, there is no, if I can put it this way, there is no public identification. I mean, I accept, of course, the litigation has led to a different issue, but in the true context of it, the facts that gave rise to the cause of action, there was no public identification of association contrary to their religious beliefs of any kind at all. And that is completely different from the Larimore case. In the Larimore case, there certainly was. And that's the beginning and end of the point. But that has to be weighed out in making a decision, as it were, on the case about whether there's a breach of Article 9.2 or indeed Article 10.2. May I put it a different way round? It is possible to imagine very hard cases, but this was not a hard case in that sense. And I make that as a legal submission, not a submission about how Mr. and Mrs. MacArthur felt about it, but an objective assessment. And that was the trial judge's assessment after hearing all the evidence on it as well. Now, it's very different from Larimore. It's different from the case where the American case, which I always forget the name of, I think it's Willie, which is the one where, what was it, Born Free... What's it? Born Free Diary, was it? Yes, it's Willie Maynard, where the driver of the motorcycle was required to drive constantly with a number plate which affirmed the view of the state. What was it? Born free. Born free.
Live free or die.
Live free or die. I'm sorry, it's even pithier than that. And objection was taken in the sense that he is publicly identified with having to promote it. He can't drive unless he promotes that view of life. It's a different class of case from that one. So those are the submissions that we make about 9.2 and 10.2. I think what it comes down to is that it's not enough when making an analysis of whether under 9.2 or 10.2 really makes no difference at all, of the proportionality of the impact of this in this particular case. It's not enough to simply say it's a compelled speech case. From the Commission's point of view and from Mr. Lee's point of view, we recognise that there may well be, following Gilberg, and we have no problem with this submission, a negative right in relation to freedom of expression, a right not to say. But it's a qualified right, just as the right of expression is a qualified right. And that leads me, I think, to the point that I want to make in answer to something that my friend said about the development of the SOR regulations. It is simply not true that they didn't anticipate that there may be some interchange with expressive activity. I showed you in the analysis the context of the photographer. That is an example of expressive activity. The state decided that the photographer who didn't approve of certain activities on religious matters would still be brought within the scope of the legislation. It's not the same as this, but it is not true to say that the legislator did not understand that expressive activity might be involved. Your Lordships will find it in Volume 2 of the, I beg your pardon, the Appendix, Part 2. The page is 4122, and this is the assessment in the context of Northern Ireland of the 370 plus responses that they received. It's the penultimate paragraph on that page. 4122.
Thank you.
Some respondents argued that people should be able to refuse to drive a car for a couple attending their civil partnership ceremony, or for a photographer to refuse to take pictures of such a ceremony. And that's in the context of the Christian business that was anticipated there. So the state did recognise that some kinds of expressive activity, photography is a classic example of it. Wedding photographers are chosen for their ability to flatter, and sometimes successfully and sometimes not, as many a family gathering has debated. But that is expressive activity par excellence. Indeed, it's more obviously expressive activity than simply using a commercial printing facility that prints in icing rather than in ink alone, but inked icing. So the state had in mind that there may be conflicts of that kind and drew the bright line nonetheless. Those are the submissions in summary that we want to make about 9.2 and 10.2. We don't deny that there was, if I can put it this way, a limited kind of speech act to the extent that there were words on the cake. But objectively, the extent of the attribution of those to Mr. and Mrs. MacArthur and Ashers was none. Subjectively, they felt it. All the discussions in the papers which we've shown you have been premised on the difficulty of disentangling personal beliefs and opinions of a religious nature from unacceptable discrimination, and therefore the need to have a bright line in the context of delivering very often very small sums of value in goods, facilities and services, where legal certainty is critical, because you can't resolve it by going to court and deciding what to do. Now, many of those submissions about the justification were made in Bull and Bull and Hall and Predium. My lady will remember them. We made it most powerfully by simply saying this, that Mr. Hall and Mr. Preddy couldn't wait for a court to determine whether they could have their pre-booked bed. There had to be a bright line at that point, and that was specifically anticipated. It is true Mr. Lee could wait a little time, not quite so urgent as that, but the need for legal certainty in this context is absolutely real. Those are my major reply submissions. I've got one or two very short points to make, if I may, in answer to some of the cases. I was rather reassured when my friend got out the learned jurist's submissions on the masterpiece litigation this morning. It's tab MS 2581, bundle 8, paragraph 116. Because it seemed to me to provide at least some support for the view that the Commission has taken about how the offer might have been reconstituted. The paragraph was page 2581, and I suspect the point has not been missed by the court. The distinguished jurists in that case said, as you can see, Colorado artisan might decline to create for any and all customers messages saying, "God bless this gay marriage," or "the South will rise again," for the simple reason that Colorado law does not seek to regulate messages, but to prohibit discrimination against customers. But if a cake maker willingly creates and sells cakes saying, "God bless this marriage," he cannot decline to complete such a sale upon finding out that the purchaser or user is gay. Not quite this case, but it is a fact that in the course of the cross-examination of the MacArthurs, it was accepted that if the word gay was removed, they would have supplied the cake, which is, of course, the equivalent of saying support marriage. It is, I understand the point that my Lord Mance said, that if you simply said that we won't do cakes with political messages, somebody might come along and say that is a class discrimination of the kind that one has suggested. I can see that argument, in which case that the offer's got to be reformulated in some other way. Our simple point from the Commission is it's not our task to write the offer for any commercial business. They have to work out how to do it in accordance with the law. But what they mustn't do is make a general offer and then discriminate how it is actually applied. And that's the point, essentially, that was being made in that passage by the jurists there. Brocky. Brockie's been much discussed, and I've certainly had to discuss it with at least 2 members of this court previously. We submit that the Court of Appeal's assessment of the appellant's argument in Brockie at paragraph 68 MS 3212 is one which you can easily adopt. We actually showed the Court of Appeal that there was subsequent litigation in Brockie on the costs of the appeal, and Brockie had to pay the costs of the other side. Essentially what happened in that case was that Brockie was required by the board and by the appellate authority to comply with the order that had been placed. The order that had been placed, or sought to be placed, was to have the logo of the gay community, that the gay body that asked for it, on its letterhead and its envelopes, and that was endorsed by Brockie. But it was thought that the order went a stage too far, in the sense that the order of the Board of Inquiry might have gone to a point at which it was essentially undue. It might have extended too far. But that's not actually the offer, the request that had been made at that stage, and that's why the order was changed. The refuge that those opposing the kind of argument that I've advanced have sought to find in Brockie is that there must be a limit to what can be required. We don't need to engage with that part of the argument in this case, bearing in mind the objective assessment of the trial judge. So that's all I need to say about Brockie. I want to say just a few words about McConkie. It was submitted that McConkie was a case in which it was said that the political opinion had to be that of the victim. It's tab 51, bundle 3, MS 1004. The case is about an entirely different point from that which is before us today. There was no argument about whether it might be the political opinion of the discriminator. And in fact, if you read it, it's perfectly clear that the alleged discriminator, the Simon community, did have a political opinion which was directly opposed to the one that had been espoused by the employees or the persons who'd applied for employment. The case is not about the subject matter of this case. And I want to make a further point about Fito in relation to this, which goes to an argument which goes nowhere anyway on the conclusions of the judge, that it has to be the opinion or belief of the alleged victim which is the ground for the discrimination. If you read Shamoon, you will see that it was a sex discrimination case. Under the sex discrimination legislation as enacted, it had to be, the ground had to be the alleged victim's gender. Less favourable treatment on grounds of her sex was how it was initially enacted. A year later, when the Race Relations Act of 1976 was passed, the possessory pronoun was not added into the legislation. It was on racial grounds, and that was then defined as meaning race, ethnicity, colour, and so on. The possessory pronoun has never been continued. It's not in the Equality Act. The gender legislation has changed. It is true, as my friend says, that originally in the sexual orientation regulations, the religion and belief regulations for England and Wales, it was said it had to be the political opinion or belief of the individual victim. But that provision has been removed in the Equality Act, and it was not replicated in the sexual orientation regulations. So there is nothing in any of the legislation which says that it has to be the individual's political opinion or a religious belief that is the ground itself. It can be any political opinion or religious belief. And that is equally true in relation to sexual orientation. There is no possessory pronoun. The direction of travel in discrimination law has been to eliminate that aspect of it because it was seen as being over-restrictive and allowing discrimination to occur which was not acceptable. In any event, as we recall, Mr. Justice Nicholson had dealt with this point long since, and that was set out in the submissions that were accepted at first instance and indeed on appeal. I think I pretty much hit the buffers at that point.
Sorry.
Would you allow me just 1 minute to turn round, my lady, in
Just
case I've
find
done
out,
something
yes.
wrong
Yes.
or omitted something?
Sorry? Yes, of course. No, Mr. Allen, Lord Mance has a question for you.
Well, I'll ask it before or after, but it's slightly off the subject you've been addressing, so you better finish what you wanted to say.
I finished, my lord.
Right. Can I ask you this? On the question of the scope of any appeal which might be in front of us, do you have anything to say on the point raised by the Attorney General to the effect that the Court of Appeal, if he's right, should have deferred, should have stayed its proceedings pending a reference, and the consequences for the Court of Appeal's judgment on all issues before it, since it was given without the benefit, if he's right, of the answers to the reference?
I certainly do.
Well, it
won't surprise you. I mean, in a sense, it's a new point, but I'm going to do this off the top of my head shortly.
Yes.
And the court, I think, will permit me to do it in writing if it feels it needs it, and if I feel it within a couple of days. But the way I see it is this. You could conclude that was an error, but it would be wrong for you to conclude that it meant that the judgment was a nullity. It's not before you in argument that the order should be overturned on that ground.
Well, it may be a bit difficult for us if we come to the conclusion that we should have heard the answers to the reference. Sorry, the Court of Appeal should have heard the answers to the reference. And if there are no other routes to appeal in certain areas, are we really to turn our blind eye to what you submit is not an irregularity or not a serious one, but might be regarded as an irregularity? I mean, if you look at Anis Minnick, which is the root case in this context, this would seem to me to potentially to fall within the category of cases where, although the legislation says the decision is final or shall not be questioned, was the phrase in that case, nonetheless an appeal can lie.
Well, my lord, Anis Minnick was a rather different class of case in that sense, because it was not a case in which there were prohibitions which were worked out in the way that they've been worked out here. It was a straightforward ouster clause of a general kind. I'm doing this from the top of my head, but that's my memory of it.
Yes, I mean, we can look at it.
It is a classic ouster clause case.
Yeah, but this, in a sense, is an ouster clause case. This is a finality, an exception to the general rule that you would expect an appeal to our court.
Well, my lord, I can make a short answer to that, which is it would take turn a very long case into something that would be even longer, because if one follows through the logic of that, then what ought to have happened is there ought to have been a reference under paragraph 33. It ought to go back to the Court of Appeal with the benefit of your views about that. It opens the door to the court to decide what it makes of your opinions in due course, because that's the way it would work. It's not for you on the 33 to completely determine all the issues of it, but to give essentially an advisory question on it.
Well, I think all these are points on which it might be useful to have submissions. For my part, I mean...
my Lord, I think you'll agree that it's not fair to ask me to do it completely on the hoof at this stage.
It's a new point, you're right.
And so I'll happily look at it in greater detail about it and take the anisminic point as well. But I think it would be, A, running into my opponent's reply time, but B, I'm not going to do it as well as I would wish, just standing up.
And it may be that both sides, three sides, feel they need to.
Would you allow us a timetable of, say, 3 weeks to do that, or 10 days, whatever seems sensible?
Look, 2 weeks to you,
2
and
weeks.
then a week for any responses.
Thank you very much.
Because everybody's heard about it.
Of course.
Thank you.
My Lady, my Lords, I've asked my learned friend, the newly elevated Miss Crowther QC, to deal with the submissions in reply for the appellant, so the court will have the advantage not only of our submissions, but a fresh voice at this stage in the afternoon.
I don't know if I can promise to be fresh, but I am at least different.
Well, I'm sure we're delighted to redress the gender balance.
I'd love to be of some modest assistance in that regard, my ladies. Can I structure my submissions in reply to address 6 points? Firstly and secondly are the jurisdiction for the appeal and scope of appeal. Thirdly and fourthly, the question of discrimination and the questions on SORs and FETO in terms of the meaning of, on grounds of. And then fifthly, the questions on deference due to the legislature in this case, in respect of both FETO and SOR. And then finally, if I may, on the proportionality exercise in this case. I had hoped maybe to make some observations about the references, but I think given the hour and the amount that we've heard about those already, it may be that that is not necessary. So coming first of all to jurisdiction, my learned friend, Mr. Allen, made points about validity and the meaning of validity in section 42, subsection 6 of the 1978 Act. The reference for that, just for recollection, was MS 4144, which is, I think, on page 14 of the additional e-bundle, the one that hasn't got the correct numbering. If I've understood correctly, and I'm sure I'll be corrected if I am wrong, Mr. Allen says that validity in this sense should be limited to constitutional validity. Now, we're not entirely clear what that limitation should mean, but it seems from the submission to be that the interpretation of validity for that text should be based on what Parliament might have intended as at 1973. We say that that's not the correct interpretive approach to be applied to the statute. The general approach, which I can supply authority on if necessary, but it's section 14.1 in Bennion, and there have been various cases since, is that an updating construction of legislation is the general approach, and a historical interpretation would be exceptional. We say that's obviously the case here because an updating construction is generally to be preferred, because otherwise legislation would constantly need to be reviewed and reenacted. It's to be taken that Parliament would expect legislation to remain on the statute book for a long period of time, if not indefinitely, until it was repealed. And therefore, in those circumstances, that's why it is the general rule. Against that background, we submit that, therefore, what has happened in Northern Ireland constitutional legislation since 1973 clearly does fall within the scope of validity. So questions of devolution and the European Convention of Human Rights and the constitutional impact of that case. So even if Mr. Allen is correct that the word constitutional validity needs to be read in some way, we would submit that that doesn't really change the interpretive act here. It still covers these questions. In terms of general points of interpretation, we say the natural and ordinary meaning of validity would be something which is legally or officially acceptable. It's a common usage word, we submit, and therefore really all that word validity is doing is distinguishing between what is legally acceptable and what is not. And one sees it in all sorts of different usages in a legal context. It talks about the validity of, say, a contract. Conflicts lawyers talk about the applicable law on the question of validity, or marriages, what is a valid marriage. So we would submit it's a natural and ordinary, natural word, and the ordinary meaning should be applied. We do respectfully adopt my Lord Kerr's point that in any event, that was then and this is now, in the sense that the restriction on appeals by way of case stated is somewhat anomalous when there are other kinds of appeal, other kinds of case that can have an appeal. And then finally on that issue that Mr. Allen talked about earlier on this afternoon, which he's put a fresh note on, his submission is that we would have had a choice of appeal from the county court to the High Court, which would have been by way of a complete rehearing. And he suggests that had we taken that route, then we would have had a right of appeal beyond that to the Court of Appeal. We've dealt with this, and I won't dwell on it, because in the grand scheme of things, we submit that not much turns on it. But in our response to the respondent's notice of objection, memory stick reference 2908, we've referred to the Northern Ireland procedural text, Valentine, and I'm extremely grateful to my Northern Irish colleagues for introducing me to that great work. But Valentine's opinion, which we've set out there in our response, is that there would not have been a further right to appeal other than the one we enjoy as a result of the route that we have taken. That's not in our submission a point that we would invite your lordships necessarily to resolve one way or the other. We simply say that it can't be said that we've made our election and therefore we have to put up with it. So that's what we want to say about jurisdiction. Moving on to scope of the appeal, if I may. I handed up yesterday, after the short adjournment, the case that my Lady Hale referred to, which is the Attorney General for Northern Ireland against Gallagher, a 1963 appeals case. I'm not sure that we need to go to it in detail. The key point is actually in the headnote, and that is taken directly from the first paragraph of Lord Tucker's judgment at page 370. The short point is that where the Court of Appeal had certified a point of general importance for an appeal to the House of Lords in a criminal matter, it was then open to the House of Lords to consider the case in the round, and it wasn't limited by the point which had been certified. We would submit that that is an analogous situation to the one in which we find ourselves here, and that the justice of the case ought to, in that sense, prevail. My learned friend, Mr. Allen, made the submission that the consequences would be extraordinarily surprising if that result were true, because you could raise an appeal merely by having an ancillary point on validity kind of attached on the side of, or almost by way of afterthought. Our response to that is that all that this is about is the gateway, and there's nothing in any of this which negates the powers inherent in the court either to control abuse of its own process or to exercise discretion in terms of what issues it feels are appropriate and necessary for it to determine in order to do justice in the case. And support for that is additionally derived from the Gallagher decision, because Lord Tucker, in the passage that I've already referred your lordships to, says that there is a discretion of the House of Lords, as it then was, to determine which additional issues it would consider.
But all in the context of one claim or charge, if it was a criminal case. What do you say to the proposition that where you have two discrete causes of action, sexual orientation under SAW and religious belief or political opinion under FETO, it may be that you're within the gateway of one of them, but why should you be within the gateway of the other just because they happen to have been heard within the same proceedings?
Well, I'd say two things, my lord. First of all, we did make industrious efforts. In fact, I say we. I should give the credit to my learned pupil for industrious efforts to find the old Arbitration Act cases to which your lordship referred yesterday. And we found some, but in fact, we found so many that we felt that deluging the court would actually be not of assistance. But one of the things that one can, in general terms, derive from some of those cases is we submit this notion that labelling of issues is not always a helpful way to proceed. We would submit, therefore, that in this case, where the thrust of what is being invited here is a finding of civil liability against my client for discrimination, and that is put in different ways, be it on different grounds or as a result of different legal routes through, it would be artificial in our submission for the court to restrict itself to consideration of only some of those issues, because they are so intrinsically linked that it would be not only unfair to the individual parties, but we would go further and submit that it would not be of assistance generally to others in similar situations, and would not do justice to the wider importance of this case going forward. So
you'd also wish to say that what's complained of here is a single act of refusal said to constitute discrimination. There are species of discrimination which are canvassed. You would submit that it would be unrealistic to focus on one without addressing the other.
my lord, yes, inevitably you put it much better than I
well,
ever
it's
could.
easy
But
from
that is essentially what I'm hoping to convey.
Law, the law does seem to distinguish the two, gives different routes and so on and different possibilities. So
Well, development of law is always a bit...
if there's a really good arbitration case, do let us have it, but I don't suggest this is key to the case.
They're of some antiquation now, obviously, as the old Act, as your lordship put it, was changed in 1979. So, in terms of my legal life, 1979 is pretty elderly as well. My lord, yes, that. In terms of scope, finally, on Section 40, subsection 5 of the Constitutional Reform Act 2005, Mr. Allen says that this only relates to matters which, he says that doesn't save us because that only relates to matters which are in the appeal. Perhaps it would help if we quickly turned up the page again just so we can look at the text. It's at MS 81. It's a very short point. It's in 45. It says, court has the power to determine any question necessary to be determined for the purpose of doing justice in an appeal to it on any enactment. Our short answer to that is that if that interpretation is right, then in our submission, Section 40, subsection 5 doesn't really do anything. We say that you don't have to define what the appeal is, categorise it or give it a label. You simply need to do what Section 40, subsection 5 tells you to do, which is to do justice in the appeal before you. If I can move on then, please, to sexual orientation and the discrimination as was found by the district judge and also the Court of Appeal. In response to what Mr. Allen says, we submit that the real problem at the heart of Mr. Allen's case is that he lacks a clear finding that the cake was refused because Mr. Lee is gay. Now, it was always open to the district judge to make such a finding, but she didn't do that. That may be, and I'm speculating slightly, obviously, that it was because the respondent at first instance argued that this was a Bressol type case of indissociability. So he was saying that the message and the man are basically proxies for one another. And therefore, insofar as the district judge was making findings about the message, it may be that, given the way the case had been argued in front of her, she may have thought that that was the same. But that's not actually what she found. She didn't actually cut through it all and say, actually, a bit like in Preddy or maybe the bed and breakfast cases, the real reason that you refused this order was because of the sexual orientation of the customer. That's not the finding that was made. And that leads into some of the confusion that we've looked at in the judgment, and my Lord Mans picked up on paragraphs 57 and 66 and some of the inconsistent findings. But we would submit that there's no need to go into indissociability if you think that the refusal is because the customer is gay. If the refusal is because the customer is gay, you don't even get as far as indissociability. You don't need to look at the message. And so we say the fact that the judge went down the Bressol route is consistent with our submission, which is that that's not what she was finding. Now, I know Mr. Allen has taken you to findings in the judgment at paragraph 39 and other places where the judge made findings about knowledge. And again, some of those findings are a little bit confused in our respectful submission in terms of knowledge and perception and conscious and subconscious. But ultimately, the point is that none of those findings go far enough to establish, and none of them amount to a finding in our submission, that this cake was refused because Mr. Lee was gay. And that's when the respondent in the Court of Appeal moves its position away from Bressol and into questions of associative discrimination. And that's when we pick up the Court of Appeal judgment at paragraph 57. I think you have the reference already. It's MS 3210. And the respondent then says, well, what you do is you change the message on the cake. And I think it was fairly early on yesterday morning, my Lady Hale asked Mr. Schofield, does there need to be another person against whom there is discrimination? And you've heard just recently from Mr. Allen that he says, well, no, there doesn't need to be because there's nothing in the text. Well, with great respect to Mr. Allen, we disagree. We think there is something in the text that says that there has to be another person. And if we start with the sexual orientation regulations at page 29 on the memory stick, at regulation, these are the SORs. At regulation 3, subsection paragraph 2, so it sets out in section 1 what is discrimination. And section 2 is about the comparison that you have to undertake. And it says this, a comparison of B's case with that of another person under paragraph 1 must be such that the relevant circumstances in the case are the same or not materially different in the other. So we say that's a clear instruction to the court to compare B, the alleged victim of discrimination, with another person, and not just the material circumstances must be the same. Now, I totally take on board Mr. Allen's points about the textual development in terms of removing some of the previous limitations on the wording of discrimination, but we say that doesn't take him far enough, because what those changes did was to allow developments like associative discrimination. So it could be the protected characteristic of a person who is closely associated with B, and that would still fall within the wording, because that would be another person, but it is always a person. It's not a cake, and it's certainly not a message on a cake in our submission. And it's certainly not focused on the word gay, because we say that that isn't even the message on the cake. So we submit that none of those issues in terms of our textual analysis have really been dealt with. And when one looks at how these regulations are set up, there is not a case for it being on grounds of sexual orientation here. If I can then briefly address FETO, and similar points arise in terms of the interpretation, and I'll give you the memory stick reference quickly, we don't need to turn it up. Memory stick 108 has got, they're not identical, but they're similar provisions in FETO requiring the comparison to be with another person. But fundamentally, on FETO, we say this, the issue was always the appellant's own beliefs. Because as soon as the message was produced, the image on the cake that was going to be produced was produced to Mrs. MacArthur, and her evidence at trial, and she was challenged firmly but fairly by Mr. Allen on this, was that she knew immediately in her heart that she couldn't do it as a result of her own beliefs. And that goes to the heart of this case in terms of it being the message. And whoever had come into the shop that day with that image and that message, be it an event planner, a courier, a personal assistant, the answer would have been the same. The cake would not have been produced. So it's not about any protected characteristic, be it political opinion, religious belief, or sexual orientation. I've got one eye on the clock. I have a few points, if I may, to make about deference and also proportionality. Mr. Allen says that this case is about the separation of powers, and to some extent we would agree with him. But we differ if what his submission leads to is a suggestion that because Parliament has issued regulations in this field that the courts should step away, because our submission is that this isn't an animal defenders type analysis, but this is one where the courts have an obligation to grapple with the individual circumstances and the balancing of rights. My learned friend, Mr. Schofield, referred you to Lord Dyson's speech in Black and Wilkinson, where he did exactly that in respect of the bed and breakfast, one of the bed and breakfast cases. But we say where Parliament has created potential civil liability on the part of an individual, then it's particularly incumbent on the courts as part of their function in determining whether liability is or is not established to consider the balancing act. This is not like a true public law case, if I can put it that way, where there's a policy or a rule or a guidance, and there's a question about whether the court should step away from interfering with that. This is a framework for liability where individuals in myriad circumstances, which Parliament couldn't even begin to conceive, are going to have different interests to balance. Mr. Allen says, well, even if you do look at it, you've got to give considerable deference because the legislation in this case has been the product of deep thought. Our submission is that there may have been deep thought, but not into these particular issues that face the court in this case. For interest of time, I won't take us to all the materials, but we submit that the background to FETO, which can be very clearly seen from the SACHR report and review, is to reduce what might be termed balkanisation in the economy. I think my learned friend Mr. Larkin referred to it as the two communities. And I can give you some references where that is clearly what is the only focus of the legislation. MS 2713, chapter 5, MS 2718, SACHR's second report of 1990 at MS 2752. The general approach is to correct historical divisions along sectarian lines, paragraph 3.2 at page 2762. And similarly, in respect to the June 1997 review, there's an MS reference of 2749. The idea is to correct the historical anomaly to bring in line goods and services in religious belief and political opinion with sex and race. But the key point in our submission is that at that point, there was no thought given at all to sexual orientation discrimination, or indeed any potential clash of rights between what was being done and protections for those of those who have protected characteristics on the grounds of sexual orientation. So we would submit that it can't be said, certainly in respect of FETO, that any real consideration was given to these kind of issues in any event. Insofar as the SORs are concerned, you've been taken already to the judgment of Mr. Justice Weatherup, as he then was, in the Christian Institute case, where he found that the legislature did not pretend to cover every situation of civil liability in these cases. And we would submit that that is plainly right. Mr. Allen has pointed yesterday and today to some examples from the consultation responses, but in our submission, they all amount to the same type of case, which is a refusal to provide services associated with same-sex ceremonies or same-sex weddings. The photographer example, the car hire example, and in a related way, even the bed and breakfast cases. None of them at all talk about Article 10 and how Article 10 might be squared with this situation. And none of them deal with the situation that you have before you. And against that background, we submit that the only fair and appropriate thing to do is to balance the interests on an individual basis. Finally, on this topic, before I just touch on proportionality in general, Mr. Allen has submitted that you should leave a bright line here because there's a risk of uncertainty. We submit that the situation in which our clients are left, if Mr. Allen is right in his case, would be one of considerable uncertainty. There was a lengthy exchange yesterday afternoon in which Lord Mans sought to elicit from Mr. Allen on behalf of the Commission what the position of our clients would be and the extent to which we would have to withdraw from services and the market. We submit that the only safe course for somebody with religious belief would be to withdraw entirely, at least from bespoke services or any services where a member of the public could make requests as to content, because anything else, it seems, would be putting them at risk. And we submit that that is simply too uncertain, too high price to pay. Finally, if I may, on proportionality, Mr. Allen has, I hope I'm not being unduly dramatic, waved a bit of a shroud this afternoon, suggesting that the courts might be inundated with cases of unmeritorious and perhaps even spurious or abusive suggestions of religious belief motivating discrimination. Can we be very plain that there has never been any doubt in this case that the beliefs of my client warrant the protection under Article 9 and Article 10. If one needs authority for that proposition, one can look at the Christian Institute case, which is memory stick 1058 to 59, paragraph 48. There is a threshold test under Article 9, which beliefs have to cross in order to be worthy of the protection under the Convention. They have to be serious, and they have to be suitably respectful of human dignity. There has never been any question in this case, but that the beliefs of our clients are worthy of that dignity and respect. And therefore, the risk that is posed in front of you, we would submit, is anything other than real. And finally, if I may, just on the Larimore case, it was suggested that the finding of the district judge in respect of the beliefs of our clients was effectively binding on this court. We would submit that the court is entirely in a position to take its own view as to the value and weight to attach to the beliefs for two reasons. First, obviously, no criticism of any courts below. Larimore was decided after both the first instance and Court of Appeal judgments in this case, and it is made plain there by Lord Mans that the question of the belief and the association with the message would be a largely subjective one. And therefore, secondly, we submit that to the extent that there is a purported finding there, it cannot safely be said to have been made on the correct basis, because obviously they didn't have the benefit of that learning at that time. But in any event, and moreover, there was it's very clear in our submission that it can't be for the courts to seek to rationalise and to apply logical, objective standards on something which is so intensely personal and subjective, and in some cases not amenable to that type of analysis. And therefore, for those reasons, the assessment in Larimore and the way to go is plainly right. I'm conscious of the time ticking on, and that Mr. Larkin...
Time limit.
We absolutely have.
You have.
And I was going to say something about Mr. Larkin's case, but I'm not. I'm going to sit down. But thank you very much.
No, Mr. Larkin can say what he likes about his case. Yes. Thank you very much indeed, Mr. Allen.
Ladies, Lords,
No, thank you. 9 points, very briefly. Conscious of the iron boundary set by 4 o'clock. Firstly, my learned friend, apropos of paragraph 33, made 2 points. He suggested that comity, as he put it, was an aid to interpretation, and secondly, he sought to pray and aid the notion of due process. If one looks at MS 133, one finds that comity says nothing about the substantive interpretation of paragraph 33 insofar as the 4th issue referred is concerned. And indeed, comity doesn't even advance very far within its own terms, because if one looks at the law officers, with the exception of the locally based law officer, it's not the other devolved law officers, such as Counsel General for Wales or the Lord Advocate. It is the UK's shadowing law officers, as it were, who are tasked or entrusted with the power under paragraph 33. And as the court will know from its own experience, there isn't a single instance of paragraph 33 being invoked by any of the UK law officers as respects this jurisdiction. Secondly, in what to me at least were rather terrifying submissions, my other friend characterised our argument about section 17 as either eating itself or proving too much. That appeared to resolve an analysis to pointing out that Section 17 didn't bite in relation to the 2 UK statutes, the Fair Employment Act 1976 and the 1989 Act. Well, he's absolutely right about that. But then Section 17, that's at MS 166, was never aimed at Acts of Parliament. It was only ever aimed at measures of the Assembly, or as we now know, the subordinate legislation made under the 1974 Act. Secondly, and in any event, in the context of employment, the issue raised in the first 3 questions referred relates solely to compelled expression. And it is really difficult to see, to put the matter no higher, how compelled expression can possibly arise in an employment case. But we're, I suppose, turning the terrifying concept of an argument eating itself back, perhaps, on my learned friend. His attempt to minimise Section 17 and Section 24 is perhaps paradoxical, because on the one hand, he is attempting to enhance the impact and authority of 2 subordinate pieces of legislation, veto and SOAR, and yet at the same time deprive the constitutional protections against discrimination of their proper effect. And since textually these provisions are in important respects so similar, that is, if I may say so with respect, rather an odd argument. Because it simply cannot be that the only discrimination that is caught by Section 17 and Section 24 is ex facie discrimination. There is simply no argument for reading it that way. My learned friend refers to class, but of course what refutes that position fundamentally, we say, is the provision within Section 98 MS 130, of course, of the inclusion of class or individual or class of persons. So legislation can discriminate against an individual. and we see, respectfully, no basis for disapplying the now canonical approach to indissociability that's been espoused in Bullen Hall and Preddy. Fourthly, we, in response to the animal defender's point, simply say that a bright line rule, you can't have political content advertising on broadcast media, is fundamentally different from a liability creating provision such as the two provisions in FETO and SOAR that are at issue here. Fifthly, because this is a compelled expression case, this is not a conscience clause case, such as would, for example, be discussed in the context of a bed and breakfast situation. This is purely about compelled expression. And when, sixthly, we hear from Mr. Allen that the Commission get cases of people who object to serving individuals in a mixed-race relationship on supposedly biblical grounds, the response is twofold. One, that's clearly race discrimination and is properly actionable. But if someone came into a shop that printed T-shirts and said, we demand that you print a T-shirt saying loving against Virginia was correctly decided, might be a rather silly message, or a very good message, depending on one's point of view, but that the T-shirt owner couldn't be compelled to print that. He couldn't refuse service to a mixed-race couple, but the mixed-race couple can't compel him to uphold the juridical value of a decision of the US Supreme Court. Seventhly, in the Bank Mellon analysis, my learned friend reluctantly conceded the subjective analysis at the fourth stage, but we respectfully remind the Court that this case falls at a much earlier stage because there really is no justification. It's not a valid policy choice to compel speech in any direction. One can quite easily provide full protection in terms of the delivery of goods, facilities and services without discrimination, without compelling speech. And we again respectfully remind the Court that there isn't one Strasbourg authority in which compelled speech has been endorsed as being compatible with Articles 9 and 10. And the photographer example, and that's the closest to an expressive trade that one finds in the SOR Travaux Préparatoires, is analogous, of course, to the masterpiece case. It's not this case. This is a case purely and simple about a message. My learned friend again seeks at the end to minimise that. This is our ninth point when he says that it's a limited kind of speech act. Well, we respectfully remind him of what he said in his skeleton argument, MS 3591. It's a message, and it's a message with content. And we respectfully agree. It's very strong content, and it's content that some people will be happy to endorse, others will find it horrifying to have to endorse. And that's what this case is about. Those who find it impossible to reconcile with their consciences on political or religious grounds simply shouldn't have to. And finally, my ladies and my lords, can I, as Attorney General for Northern Ireland, respectfully thank the Court for coming to Northern Ireland. It has been wonderful for the legal community in Northern Ireland to have the Court come here to the Upper Bar Library, and just how welcome that has been appears from the people, perhaps not as many now as there were at other stages today, but it's been a matter of enormous interest, and I, for my part, certainly hope that this will not be the last visit of the Court to this jurisdiction. Thank you very much.
Well, thank you very much indeed, Mr. Attorney, and for those final kind remarks. Mr. Allen, did you have something to say?
Yeah, I want to correct a point of fact, and that's all. at page 3753, my skeleton argument.
357 or 375?
3753. It's Appendix Part 2, page 560 on the internal numbering. The court will see that I made the case on associative discrimination at the very outset in relation to sexual orientation. It wasn't a development in the Court of Appeal. It was made from the very beginning.
I don't think that our
It's a
decision
point
is
of
going
fact,
to turn
and
on
that's
that,
it, my lady.
Mr. Allen. Well, thank you all very much indeed. Do sit down. I wanted to respond to what the attorney had said because our time with you is drawing to a close. We've finished our... It's all right, Mr. Attorney, you can stay seated. We have a moot tomorrow between the students of Queen's University and Ulster University. So it'll be very exciting to see which of those two splendid institutions eventually wins the prize for being the best advocates of the future in cases before the Supreme Court. But I wouldn't want the court proceedings to come to a close without taking the opportunity to thank everybody who's helped to arrange our hearings here. In particular, of course, I would like to thank the Lord Chief Justice of Northern Ireland for his support for our visit, the Bar Council, of course, for allowing us to use what is basically your premises, the staff of the Bar Council as well, the Law Society, the universities, the legal community, the media, and particularly those members of the public who have shown an interest in our work. I hope that our time here has enabled everybody to understand the Supreme Court, what it does, and how it does it, better than they might have done just by watching us online over the internet. I'd also like to record our gratitude for the help that the staff of the Supreme Court have received from the staff of the Bar Council, of the Office of the Lord Chief Justice and the Court Administration, the Court Security and the local police. My thanks are, of course, also due to counsel in the cases that we have heard while we have been here. And the justices would like to thank our own staff who have come with us, led by our Chief Executive, Mark Ormrod, for all the hard work that they have put into this exceptional part of their duties and have helped it to run so smoothly, and obviously have been able to get on well with the local staff who helped them. This is only the second time that the Supreme Court has sat outside London. I recognise it's still something of a novelty. We're finding our way. But of course, when we come back, it'll all go completely smoothly because we'll all know what to do next. We've been very heartened by the interest in our work, and we shall now adjourn to consider our judgments in the case that we have just heard. People will, of course, not expect the answer any time soon. This is not to say that we don't hope that it might be before the summer, but these cases are, by definition, complex and difficult, and there are 5 people who have to make up their minds, and so that in itself takes more time than simply a jury's verdict at the end of even a long trial. So bear with us, but we will let you know in the usual way what turns out. And the court will now adjourn.